everyone. Thanks for joining. Welcome to BIE's Employment Law webinar. For those of you that don't know me, I'm Emma Claire Kavanagh and I co-lead the People and Culture practice at BIE. We work with business leaders to ensure that their organisations are well prepared for change. We do this by providing interim, search and advisory solutions. Today, our focus is on changes with employment law. There have been a number of reforms to the Employment Rights Bill and many more still expected to come. We're joined by James Major, a partner from Clyde & Co, who will share his knowledge on current and upcoming changes. Over to you, James.
Thanks, Emma. I'm a partner at Clyde & Co. I specialise in employment law, and I've been doing employment law for the best part of 25 years now. So I've seen a fair amount of change. And we're entering into a further period of change, which hopefully we're going to talk about extensively today. My background is principally advising employers. I advise on the sort of whole range of employment law matters, from the sort of most complex employment tribunal and high court claims through to day-to-day advisory work, advice on industrial relations, and indeed advice on corporate transactions and other issues, like chiefly as insofar as they affect employees. I act for a range of clients from a diverse range of sort of sectors, so insurance, financial services, professional services, retail, publishing, education, public sector. So I like to think it gives me a fairly broad view on the UK employment market and beyond. And as I say, it's a really interesting and exciting time to be an employment lawyer. There are a lot of challenges for us, and there are a lot of challenges for you and your businesses, and hopefully we can talk about some of those today.
Thanks, James. We've seen a lot of headlines recently about the Labour government's Employment Rights Bill. How significant are the changes likely to be?
Yeah, they're going to be really significant. I mean, as I say, I've been doing this job now for nearly 25 years, and the Employment Rights Bill is unquestionably the biggest shake-up of employment law in that time. The changes touch on really every aspect of the employment relationship, and they really, I think, redefine what the relationship will look like. It's going to be a bit of a recurring theme in this webinar. If you remember when the Labour government came in, they made various promises about what they would do within the first 100 days, and one of those was to introduce some significant changes for employers and in relation to employment law. They pretty much kept that commitment by publishing this Employment Rights Bill within the 100 days or very shortly thereafter. But it's a bit unusual in the sense that normally you'd have for changes this significant, you might have a year or so of consultations and gathering of views from across interested parties before you sort of put pen to paper on drafting a bill. It was done the other way around here, and as we'll see, it was obviously done in something of a hurry. There's a lot of detail left to be filled in, whether that's by way of amendments to the bill, or whether it's going to be by secondary regulations that will need to be enacted in order to bring some of these provisions into force and into life. But it does mean that we're now embarking on a period of consultation on various matters. There have also been various amendments that the government have tabled through the committee stages in the House of Commons, because there were things that, my view is, they intended to put in the bill and overlooked. So it is a period of uncertainty as to kind of what the eventual changes are going to look like. That, I mean, even if 75% of what's in the bill at the moment came into force in the next couple of years, it is going to significantly transform the employment landscape. And so we have to be engaged in the changes. We have to keep an eye on them during the course of this year. And although we don't know all of the detail, there are various steps that we can be thinking about doing, which will put us in the best possible position when we finally get the final text of the bill and/or the secondary regulations that bring bits of it into force.
And I guess there's a lot to cover. I mean, we could probably spend, days if we were to think about the whole bill. I think for the purposes of today, there were four things, weren't there, really, that we thought we would focus on. The first one, obviously, a big area, is redundancies, restructuring, and termination. And I guess one of the most eye-catching proposals in the bill is the protection could come in from day one for dismissal. How will this impact employers, James?
Yeah, I mean, it is, as you say, that was probably the most eye-catching of the proposals, and it was the one that made a lot of the headlines when the bill was published last year. And I mean, the devil is going to be in the detail. Those of you who've been involved in HR or employment issues for years will know that the qualifying period for unfair dismissal has been something of a political football. The Conservative Party tend to give employers more time to assess new employees, and so typically have picked 2 years as the qualifying period for unfair dismissal. And then typically a Labour government has come in and reduced that period to a year. Now, this proposal goes further in making it a day one right, effectively, so the right not to be unfairly dismissed. However, there is going to be a statutory probation period. We don't yet know how long that period is going to be, but there are indications that it will be as long as 9 months. And if you've started a procedure within that 9-month period, as long as the dismissal takes place before 1 year, the employee won't be able to bring an unfair dismissal claim. So that's how it's looking at the moment. We're going to have to wait and see what the detail looks like. It may end up not being as significant a change as it perhaps first looked on paper, particularly if, in effect, employers still have 9 months to assess employees. But I think we've seen before, when the qualifying period is reduced to a year, it does result in more claims in the tribunals because a greater proportion of employees have the right to bring a claim. There is a view that perhaps, people cast around for a discrimination claim or a whistleblowing claim if they don't have the 1-year qualifying service to bring an unfair dismissal claim. But and that undoubtedly does happen in some instances, but I think history would tell us that there will be an increase in claims if the period is reduced, and certainly if, say, the statutory probationary period ended up being shorter than 9 months, so 3 months or 6 months, I think that would have a really significant impact. I mentioned earlier that there are some provisions that sort of got left out of the bill, and one of the big ones that the Labour Party had said pre the general election was a change they would make was to the limitation period for employment tribunal claims. So for the vast majority of tribunal claims, you have to commence early conciliation through ACAS within 3 months, either at the date of dismissal or the date of the act about which you complain. And through the committee stages of the bill, the government have tabled an amendment to increase that limitation period to 6 months. So I think the two changes there coupled together, the reduced qualifying period and the increased limitation periods, I think we can expect to see a significant amount of claims. I should say, in relation to the statutory probationary period, it does look as though there will be an exception for redundancy dismissal. So you would need to follow the normal redundancy process even during that statutory probationary period. But again, we'll sort of have to wait and see on the sort of specific details. The good news about all of that is the government have said that the reduction in the qualifying period won't happen until the autumn of 2026. So we've got 18 months really to wait to get the sort of detail of the final proposals, and then to sort of start to prepare and get ready for the change coming into force. So it is a little bit down the line. But sort of moving away from the unfair dismissal rights, there's also a range of other proposals in the bill which are going to have a big impact on employers' abilities to restructure. And the first one I wanted to talk about was the abolition of fire and rehire. I think, fortunately, probably in my career, I haven't had to advise employers very often on taking, I think, what I certainly used to describe as the nuclear option of fire and rehire. But it has been there on the table as an option where you're trying to bring about significant variations of contract across the workforce, which are important for business reasons. And there is a difficult minority of employees who simply refuse to sign off, often on a matter of principle rather than necessarily any great objection to the changes that are coming in. And in those circumstances, employers have been minded to fire and rehire. Of course, P&O ferries spoiled that for all of us in one sense, by firing 800 people and offering to re-employ them on significantly worse terms. That was plainly an abuse of the sort of the right and the ability to fire and rehire, and obviously has led to a desire to preclude that practice altogether. So the government is proposing to make it automatically unfair to dismiss employees for failing to agree a variation of contract, and it would also be automatically unfair to replace somebody who refuses in those circumstances with another employee on the varied terms. So again, we're going to have to wait and see on the kind of specific detail. And it does look as though there will be an exception where it's simply not viable to continue in business without making the changes. But I imagine that will be very narrowly interpreted and a difficult hurdle to meet. So I'm not anticipating that fire and rehire is going to be a sort of particularly attractive option going forwards. And then the second change I wanted to talk about in the context of sort of redundancies and restructures is the substantial changes that are proposed to collective consultation. And in particular, as things stand, you only have to collectively consult where 20 or more employees are at risk of redundancy at one establishment. And the proposal is to do away with effectively the definition of establishment, so that employers would be required to collectively consult whenever they propose 20 or more redundancies across the UK. Now that will have a significant impact, and I think probably what many employers struggle with, particularly multi-site employers, there may not be a huge amount of communication and collaboration over what redundancy exercises might be ongoing, remembering that the definition of redundancy for collective consultation purposes is much wider and can capture a range of dismissals that might not otherwise be typically kind of thought of as a redundancy. And so I think employers are going to have to be a lot more careful to make sure that they are keeping accurate records of people at risk of redundancy and making sure that they stay under the 20 people. I mean, one interesting unintended consequence is that obviously it will be 20 people employed in a particular legal entity. So it'll be interesting to see if companies start organising into smaller limited entities, employing a smaller number of people. So as I say, in that kind of example of multi-site employers, whether you have everyone at site A employed by A Limited and everyone at site B employed by B Limited, would be one way of sort of doing away with that issue. But if everyone's employed by the same legal entity, great care is going to have to be taken over how many redundancies you've got going on at any one given time, to make sure that you stay below the 20.
And I guess with the level of uncertainty of exactly what will come through in the bill, what practical advice would you give to people? Because what we can't do is wait until we know, because we won't have time then to actually do the preparation and all the groundwork. So what advice would you give people now so they could start in at least getting some preparation done in advance of what could come through?
Yeah, it's really difficult, because on one level you'd want to wait for the detail before you sort of start making concrete plans to change things. But on the other, we know from examples like GDPR and then more recently the duty to prevent sexual harassment that sometimes these changes get trailed for quite a while, and then the detail comes out, a matter of weeks, in some cases days, before the sort of the go live date of the new legislation, which doesn't give anyone very much time to prepare. And if you you haven't done the groundwork and you haven't at least laid the foundations, it can be quite difficult to then respond. I mean, I think interestingly, probably one of the unintended consequences of the banning of fire and rehire will be employers looking at introducing more flexibility and the ability to vary terms and conditions within the employment contract. So one interesting starting point would be to review your existing contracts and look at how much flexibility you have. There are probably terms like place of work, etc., where typically people do reserve a good amount of flexibility to vary the contract. But there may be other areas where you want to look at and think, well, maybe we could introduce more flexibility to vary the contract without needing consent and therefore avoiding the kind of risk that somebody simply refuses to agree. So that would be one thing. Another would obviously be looking carefully at your redundancy process, particularly collective redundancy process, looking at how you capture data around redundancies and be much more disciplined, and perhaps have I mean, I often suggest to clients of having a sort of running log of redundancies, and because it's measured over a 90-day period, and once the person leaves employment, they drop off, you can quite easily, if you have a running log of redundancies, you can quite easily keep track if you have that sort of tracker. So introducing processes like that would be, I mean, I think that's a good idea anyway, but certainly will help given some of the changes that are proposed.
And what are your thoughts as well? I know there are some significant proposals around trade unions and the 0 hours contract as well, aren't there?
There are, yeah. I mean, the trade union proposals are fascinating, really. It's going to be very interesting to see what impact they have. On one level, the impact might not be as great as we think, but they seem to have given the trade unions a lot of the sort of the powers and the improved access to the workplace that the unions were clamoring for. And I've certainly seen a significant increase in trade union activity in the last sort of 12 to 18 months as the unions have been sort of flexing their muscles ahead of a Labour government, and then since then have been sort of pushing hard for reform. So it's going to be very interesting to see how these changes impact it. What we're looking at in terms of changes is just some of the headlines would be a requirement on employers to inform their staff of the right to join a trade union. So it will be a requirement in the Section 1 of the Employment Rights Act requires certain terms and conditions to be specified in a written document, and one it will be added to that, a requirement that the employer advises staff of their right to join the union, and that's going to be an ongoing right. So we don't quite know what that looks like, but presumably it will be an obligation to remind staff at regular intervals that they can join a trade union. It's also going to give trade unions the right to access to the workplace, whether that's to drum up support for union membership, whether that's to promote union activities or promote industrial action. So unions will have a right to negotiate an access agreement with all employers, whether the union is recognised or not. And so that, I think we'll see unions using that to try and gain access to workplaces that they've traditionally not been able to sort of crack and really get into in order to get recognition. And then there are further changes to the recognition process to make it easier at lower thresholds for the unions to be recognised by employers, and then changes to the balloting process for industrial action to make it easier for a union to get a positive result in a ballot for industrial action. And there've obviously been some pretty high profile industrial action over the last sort of 12 months, not least Amazon, where the unions lost very closely a vote on industrial action. It'd be interesting to see under the new, under these revised proposals, that vote would have gone through. So it will be interesting to see what impact it has. There has been sort of suggestions of, does that mean we're going to see trade union recognition in law firms and financial services firms which have traditionally been sort of relatively union-free environments? I suspect it won't go that far, but I think we will see the unions being more active and having more recognition with more employers, and also pushing for access to workplaces that they traditionally haven't perhaps had much scope in getting into. And then you also mentioned 0 hours contracts. I mean, obviously, 0 hours contracts is another one of those sort of things which, for a variety of reasons, like employers like Sports Direct and others who might have been in the headlines in the past for, what were regarded as exploitative 0 hours contracts. I think there is a view that they're a bad thing. They are, in my view, actually quite a positive thing, and they can work very well for a certain employee who wants a good amount of flexibility to work when they want and to turn down work when they don't wish to work. But I think it does seem that we are going to get some, I mean, the proposals are very, very complicated and very difficult to get your head around as to exactly what it means. But effectively, staff on 0 or low hours contracts are going to have a right to demand guaranteed hours. So they would be able to look back over a 12-week reference period, or we think it's likely to be a 12-week reference period, to look back at what hours they had actually worked, and then they would have a right to contractually work those hours going forward. I mean, that just how that works with employers who employ seasonal labour, say over the summer or over the Christmas to cover a busy period, etc. I mean, how it actually works in practice, I don't know, but I think that is at the more complicated end of these changes, and we are going to need draft regulations to bring that in. So I think that really is one of those watch this space to see what the changes look like.
Thank you. I guess another key theme that we wanted to talk about was the culture and workplace behaviour. There have clearly been some really high-profile issues in organisations, and places like the BBC, CBI, McDonald's. They all get very high-profile coverage. What changes have we seen already? And I guess there's going to be more to come as well, isn't there?
There is, yeah. So October last year, we got the new duty to prevent sexual harassment, which essentially puts a positive duty on all employers to take reasonable steps to prevent sexual harassment. And those employers who fail to do that will face an uplift in tribunal compensation of up to 25%. So in an instance of sexual harassment and substantial damages being awarded to somebody who feels that their position is untenable and they can no longer work at that organisation, the uplift could be very significant in itself. And what we see with the new bill is that it's going to expand that duty to prevent sexual harassment. It's going to move it from, and this is a sort of classic lawyer issue. It's going to move it from reasonable steps to all reasonable steps. Now, I'm not entirely sure what reasonable steps mean. I'm even less certain about what all reasonable steps mean. That will all need to be worked out in the fullness of time in terms of how tribunals interpret that legislation. But there's no question that the new duty that's in force now requires employers to go a significant way to prevent sexual harassment. It's suggested that employers should be undertaking a risk assessment of their business, looking at what changes they need to make in order to protect people, should be implementing training in the workforce, should be supporting and training managers to make sure they know how to deal with complaints that are raised. All reasonable steps is going to require employers to go a step further than that and to do absolutely everything that they can to stop instances of sexual harassment happening. There is also a proposal in the bill in relation to third-party harassment, so to effectively make it unlawful for any third party to harass one of your employees, not just on the grounds of sexual harassment, but much broader than that. So on any of the protected grounds in the Equality Act. So that's then going to put employers under quite a significant obligation to think about how they interact with third parties, whether that's clients, customers, whether that's suppliers. If they're inviting clients, for example, to drinks in the evening or to a dinner, what does all reasonable steps mean in terms of stopping sexual harassment happening? Does that mean reminding your clients ahead of an event like that that you have a zero tolerance approach to sexual harassment, and any allegations of such will be treated seriously and reported to their employer, etc., etc. Interestingly, I've already had one employer send us a letter as a provider of legal services along those lines, really, of saying, you're a third party provider who we use a lot. We have a duty to protect our staff. Here's our policy, and how we deal with harassment in the workplace. And please confirm you've shared this with everybody who might come into contact with our people, which is quite a proactive step. And I don't think most employers have sort of currently interpreted the legislation as requiring them to go that far as yet. But undoubtedly, when these changes in the new bill come into force, then I think those sorts of steps will become much more common, and we will see many employers, if not all doing that. So I think the message on that one is, certainly if you haven't yet started taking steps to deal with the current obligation to prevent sexual harassment, then now's the time to start. You're certainly not alone. We've been sort of banging the drum for some months now about needing to do a risk assessment and get an action plan in place. And not everybody has sort of taken up that invitation as yet. So you're definitely not alone, but now would be the time to start tackling it, because probably come early 2026, when we expect most of the changes in the Employment Rights Bill to come in, certainly when that comes in, you're going to be required to go even further. So to have at least thought about kind of where we're at the moment would be sensible.
And the bill as well, it looks like it's going to really strengthen the rights of employees to put more requests in for flexible working as well, isn't it?
It is, yeah. I don't know about you, but we see an awful lot of flexible working requests, and I think probably the most common area where we're seeing flexible working requests at the moment is where an organisation tries to change the sort of balance of hybrid work. So it tries to get employees back into the office more regularly. We've seen quite a lot of newspaper headlines of companies bringing people back full time, or trying to increase the amount of time employees spend in the office. And that we seem to be at a sort of inflection point of quite a lot of employers sort of moving towards more time in the office. And typically the response to that is you get a lot of flexible working requests of people asking to continue to work on the basis that they have been, in their view, successfully working for the previous 3 or 4 years. And it's even under the present regime, it's quite hard to turn those requests down. Now, under the proposals in the new bill, it's effectively going to shift the sort of obligation, really, so that flexible working should be the default, and an employer has to have a good reason. And again, it'll be one of 8 statutory reasons, as it is at present. But you do have to go. It does look as though you're going to have to go further in terms of explaining the reason, and the presumption will be that you should be agreeing to flexible working rather than declining it. So again, I think from sort of early 2026, we are going to see a shift, at quite, how that sort of impacts. I think employees are going to feel more empowered to make flexible working requests. I think they're going to feel more empowered to challenge decisions not to allow them to work flexibly, particularly if they've been doing it, as I say, in their view, successfully for a period of time. So I think the lesson for that is, well, if you are thinking about introducing that sort of change, of getting people back into the office, then doing it this year might actually be better than doing it next year. My sort of salutary advice to that would be, just make sure you've got the resourcing in place to deal with the flexible working requests, and that you've thought about upfront about if people do ask to continue their existing working patterns, is the default going to be to say yes to them, or is the default going to be to say no unless there's a good reason? And if it's going to be no, what is the basis for doing that? So get your sort of ducks in a row about what you're going to say ahead of time.
Your thoughts on countries like France and Ireland? I know they've implemented a right to switch off policy. Do you think that will happen here?
Yeah, I think it will. We've been saying for a few years now that we think that there will be we will end up in the UK with a right to switch off or to disconnect, as it's variously referred to. It is, as you say, has been introduced in France and in Ireland. It looks as though the right will be introduced by way of code of practice in the UK. We're expecting that code of practice at some point this year. What the detail of the right is going to look like, we just don't know at this stage, but it's inevitably going to come in, I think. And it is that, it is so difficult now, isn't it, to switch off. That emails are so pervasive, and you've got instant messages and WhatsApp and phone and all the rest of it. It is so difficult for employees to switch off, and so I think it is inevitable that in circumstances where that is recognised as a problem and difficult for staff in certain sectors, that the government are going to step in and require employers, at the very least, to have a policy on the right to disconnect and give employees the option to sort of opt into it, or to say they want periods where they are not contacted. And so I think that as a minimum is inevitable. Whether it goes a bit further than that, I think we'll just have to wait and see.
And another key theme area is diversity, equality and inclusion, obviously all big topics in themselves. There are some significant proposals around those areas, in particular with the family-friendly policy side of things and family-friendly rights. There are some proposals around pay gap reporting, and I'm smiling because we're already seeing projects coming through in that sort of pay gap reporting and equal pay. What are you seeing in that area, James?
Yeah, I mean, I think gender pay gap reporting has been a really positive thing from my perspective, and I think it's those employers who take it really seriously and have proper action plans around how they're going to improve their gender pay gap and reduce it to zero, and have really engaged in that. I think have really seen benefits, and reputationally, I think that's been really good for them in the market in sort of attracting talent. I think what we're going to see in the new bill is a requirement that everybody has that sort of action plan in place. So it won't simply be enough to publish your gender pay gap. You will have to have an action plan. Certainly for employers over 250 staff, will be required to have an action plan in place, which shows what they are doing and what they propose to do in order to address the gender pay gap. We've also seen instances exposed of employers using contract workers and others to sort of try and distort their gender pay gap figures so that they don't look as bad as they would otherwise be. And there are some new proposals within the bill which will effectively do away with that. One of the things we've been saying for some time is we will see gender pay gap reporting extended to other protected characteristics. And we do now have a proposal on the table that we're going to get a new equality, race and disability bill expected in the summer of 2025, which will effectively expand gender pay gap reporting to cover race and disability. And so that's going to have a significant impact. I think, the focus thus far has perhaps been on gender pay. I think the focus is then been much more broadly on pay transparency and on pay fairness and ensuring fairness across the piece, because once you start to have to kind of produce stats in relation to race and disability, it's only a matter of time before that becomes even wider and extends to other protected characteristics. And I think it is going to drive, much more change and more transparency. The other thing we're going to see is equal pay protections extended to race and disability. So that will have a significant impact as well, giving employees a greater right and ability to challenge pay that they believe is discriminatory on the grounds of race and disability. And then the final proposal is an enforcement unit, probably along the lines that we see in relation to national minimum wage, and quite what that enforcement unit will be able to do I don't know, but it will. What we've seen with minimum wages, certainly if you get an employee complaint about minimum wage and the enforcement unit picks it up, then they do a root and branch view of the organisation to assess whether there is a broader problem, and then they hit the employer with a fine if they're found not to be paying the minimum wage across the board. So I think with that sort of potentially that sort of proactive enforcement going broader than say just a handful of employees or one employee complaining about their pay, I think we're going to see some pretty significant changes. Inevitably, if that comes in 2026, the first reports won't be until 2027. We won't see change for some years yet, but I think going forwards, it is going to have a significant impact. As we did with gender pay gap, I mean, our advice would be start to think about your diversity data. I mean, I think gender data probably is the sort of the best captured of the diversity data. I suspect it's a bit more patchy when it comes to perhaps not race, but certainly disability. And it is going to be the bedrock of this right is going to be understanding who you employ who has a disability and who you employ of different races and ethnicities, and being able to report on that in terms of the pay. So you're only going to be able to do that if you've got the accurate diversity data. So a task for 2025 is undoubtedly to look at your diversity data collection, get your house in order, make sure you update your privacy notices. So from a GDPR perspective, employees know what data you're collecting, what you're storing it for, and for what purposes. And then you'll be in the best possible position to look at the detail of the proposals and respond to it.
And what about the proposal in regards to the changes potentially to the family friendly rights as well?
Yeah, so the bill's going to introduce day one rights to paternity leave, to unpaid parental leave, and to unpaid bereavement leave. I suspect for many employers that won't be a massively significant change, because I certainly know a lot of my clients already probably offer that sort of leave already. I think another change is to you'll be entitled to unpaid bereavement leave for each bereavement, and that's not kind of clear currently. So there are going to be a bit of an expansion of those rights, but I suspect that probably won't be hugely significant. Probably the more significant change is the extension in relation to the protection from dismissal for mothers returning from maternity leave, from others returning from periods of paternity leave and parental leave, and they will have a protection for 6 months after they return from work, and similar to the way in which mothers on maternity leave are currently protected. So that will provide a sort of more significant protection for those returning from maternity leave, particularly in relation to redundancies. So there are some changes proposed, but I think, I mean, my sense is there's been a really positive shift in the last sort of 5 years towards much more family-friendly policies, and so most employers, I think, have pretty good both leave and pay policies, frankly, in relation to family-friendly leave. So those changes may not be as significant for many as they might otherwise seem.
And the final theme for today, albeit there are many other themes that we could focus on in another session, is wellbeing and mental health. I think what we've seen in a lot of organisations is an increasing issue of employers having to deal with mental health issues, and that can be needing to focus on strategies to help people, but also managing the absence of people as well. What changes are you anticipating in this area with the new bill?
Yeah, I mean, it's an increasing problem, I think, that we're seeing, and I think we've probably seen it coming, but that doesn't make it any easier to deal with. I mean, I think there was a report last year that suggested that there are 2.8 million people off work on long-term sick. I think the same report suggested that 34% of young people have some form of anxiety or depression. And that is manifesting itself in the workforce. We are seeing significant volumes of absenteeism, we are seeing significant problems with long-term absences, and we're seeing employers really grapple with how to deal with mental health issues in the workplace, because they're harder to spot, and often managers are perhaps not as well equipped at identifying employees who are struggling with their mental health, and being equipped, frankly, to have the honest conversations that would be necessary to sort of then put strategies in place to help them. So it is a problem. I mean, in one sense, it's a problem that the government has identified as well as employers. So the government has got a range of initiatives that it is looking at. It produced a paper last year, Get Britain Working white paper, with a variety of initiatives to try and tackle absenteeism and to sort of get Britain back to work and improve things for employers. I think it's going to be some time before we see those initiatives really having any kind of impact in the workplace, which sort of leaves employers for a period kind of struggling on their own. There were obviously a lot of initiatives out there, and some really good ones in terms of you know, initiatives in relation to mental health, to improving the culture of a workplace and improving work-life balance. We've seen, employers introduce strategies to support employees through the menopause. We've seen much more awareness of neurodiverse conditions, and much more awareness of employers as how they can harness that neurodiversity and what they can do to sort of encourage staff to play a sort of full and active part in employment. So it is tricky. I mean, it falls back on all the old, making sure you're proactively managing long-term absences, make sure you're putting in place support for employees, whether that's internal support or through initiatives like EAPs and other external sources of support, and equipping your managers to have those sorts of difficult conversations with staff. But it is a real problem, and I think I would hope that this year is one where we see some significant strides forward in terms of helping employers deal with what I think is a kind of growing mental health crisis in the workforce, really. And so hopefully we will see some practical answers kind of come through over the course of this year.
You mentioned there as well, I'm smiling again, probably for personal reasons, but you mentioned awareness to the menopause recently. How is that going to be incorporated in the bill, and what changes do you think we might see?
Yes, I mean, on one sense, it's been really great that there's been a sort of growing awareness, hasn't there, of the menopause and the way in which it impacts staff in the workplace, and we've seen some employers, pull together action plans and menopause policies, and really understand the kind of impacts it can have, and do some fantastic things. So that's really positive. And what we've seen from the bill is that employers who have 250 or more staff will be required to have that sort of action plan that sort of properly identifies what the potential issues are for staff going through the menopause, and how they can be supported, and what changes to policies do employees need to bring in, what additional training should they be doing, and so it will be a requirement to have that. As I say, I mean, I think it's great that employers have been doing that of their own volition in recent, probably in the last 12 months or so. I would encourage anybody who doesn't have a menopause policy to get one in place, and to start coming up with your own action plan. We don't know the specifics of what the action plan will require, but it can only help if you put in place an action plan now, and start to think about these issues and how you can support employees who are going through that period in their life. So yeah, I think that'll be a really positive area when the bill comes in. Just again, sort of greater awareness of the issue and some practical solutions to try and tackle the problem.
Thank you, James. There are so many areas that we could carry on sort of talking about, but I guess thanks for your thoughts on all of those sort of four key themes so far. We've had a few questions that have come through, and one that I think is very interesting and a very broad question in itself. Does this proposal seem to offer more protection for employees or employers?
Yeah, I mean that is a really good question. I mean, I think the honest answer to that is that it's a pro-employee, it is a set of pro-employee changes for the most part. It gives a range of additional protections to employees. It gives a range of additional rights. And so I think by and large it is sort of what one might expect from a Labour government, which is a bit more sort of greater employee rights and greater rights for the trade unions and bodies like that. So yeah, I think on balance it is without doubt a sort of pro-employee set of changes. Whether some of that gets watered down in the final bill, we will have to wait and see, and whether in practice that's how it works out. As I mentioned with the sort of day one unfair dismissal rights, it's quite a headline grabbing change, but when you pick away at the detail of it, it may end up being not dissimilar from them introducing a 1-year qualifying period for unfair dismissal, which we had for over a decade. So let's wait and see.
Another question came through on the extending of sort of the reporting really from a pay perspective. And I guess you mentioned there from having data on gender is probably easier to look at, but race and disability and opening that up, will that mean that employees are obligated to provide that information as part of their, sort of their HR records?
Well, that's an excellent question. I mean, I suspect the answer to that is no, because I suspect the government wouldn't want to legislate to require employees to provide that information. And of course, you will only be able to report on the basis of what you know. But the quality of your data and frankly the accuracy of the data and therefore the accuracy of any pay gap that you have is almost certainly going to be determined by the accuracy of the underlying data. So I think making those changes now to the way in which you collect diversity data, encouraging employees to provide the data on the basis that you need this data in order to assess things like gender pay gap, what will be race and disability pay gap, to ensure equal pay across the protected characteristics, particularly gender, race, and disability, which would be the ones where employees have equal pay protections. But I think it will be, there's some good incentives there on staff to provide you with accurate data. But I think my guess is the proposals will stop short of any kind of requirement that people answer questions fully and honestly, and will be left to individuals to choose what they're prepared to disclose.
And then another question really is, are you anticipating any improvements to employment tribunals themselves?
That's a broad question. I mean, I guess there are a number of ways that one could answer that. I mean, I am concerned about the ability of the tribunal system to deal with existing kind of caseload, let alone a vastly increased caseload. And so I would have concerns. I think there's going to have to be a significant amount of investment in the tribunal system, particularly from an administrative perspective, for it to deal with a significant increase in volume of claims. I mean, the good news is that probably won't be necessary. Well, the changes won't come in until autumn 2026 at the earliest. We probably won't see an increase in claims flowing through until 2027 at the earliest. So there is a good period of time to sort of improve the tribunal system administratively in particular. But I am concerned about that. I mean, pre-COVID, the target was 6 months from claim being issued to final hearing. And I think, in sort of more than 90% of cases, the tribunals, it varied across the country, but they were pretty good at hitting those targets. I mean, my own experience is now it's closer to 18 months to 2 years, really. And that is too long a period to wait, in my view, to resolve employment issues. And we're going to have a whole host of additional claims that could get worse. So yeah, I would like to see some reform of the tribunal system, but I don't think.
Probably the final question, and you may not even have the answer to this, but when do you think we're likely to see the final bill?
Yeah, I mean, that's a really good question. So there are a variety of consultations ongoing at the moment, and I would imagine that we would see a revised version of the bill at some point during the course of this year, probably in the second half of this year, with a view that it comes into force in early 2026, probably April or May, sometime around that. So if that was the reality, then we would have 6 months to kind of see the detail of the changes. What I would say is, and I've touched on this a couple of times, a number of the changes are going to require secondary regulations to actually enact them. The 0 hours, low hour contracts issue is a sort of good example of that. It's going to need a set of regulations clearly to govern the detail of that. I doubt very much we'll get those regulations at the same time as the revised bill. I'm sure they will follow. One would hope they are published long before they come into force. But as I say, we have seen other instances like GDPR where you have a good idea of what's coming, but you don't know the actual specifics until quite close to the implementation date. So yeah, that would. So it's good to take some steps to get ready, so that at least you're agile and able to respond when the detail comes out.
Thank you. Huge thank you, James, for sharing your views. I'm sure you could probably spend many hours sitting down talking about, and actually as things become clearer as well, I guess, there'll be more reality around what are we having to do, but the preparation is needed now. I think what we've already seen at BIE, clearly working with clients that are going through change, there are definitely organisations who are trying to be on the front foot. So we've seen a real spike with the interim projects, for example, that we're managing. As much as we cover the whole area of HR within our people and culture practice, we are definitely seeing a real spike with employee relations, with industrial relations particularly, HR operations, as people need to review their policies, and reward, certainly with all that pay transparency and gender pay gap side of things, people needing to bring in extra resource to get ready for some of that. So, those that are ahead of the game, I think, are going to be in a strong position. But interestingly, I think within our search practice, we're also seeing some niche roles being hired on a permanent basis. And that's a really interesting change, I think, that rather than just hiring generalists or some of the typical roles that you would see, some very niche specialist roles as well. So that's, certainly a sign of the times. And I'm sure some of the things you're seeing with your clients, there's some similar comments coming through there as well. But thank you for joining today.
Thank you for having me, and thanks all.